how to answer a problem question in equity and trusts. The key topics to revise is three certainties and formalities: charitable trusts, non-charitable purpose trusts, fiduciary duties, and gifts. I believe that these are like the most important that you need to know in order to get a good grade on your upcoming equity and trust examination. Make sure that you review all these topics and answer a problem and essay question on each of this topic to be prepared for your upcoming exam. Also, it is important to use the IRAC structure. So every time you answer a problem question, it doesn't matter if it's about equity or anything else, you have to use the IRAC structure. You have to first start by saying what is the issue at hand that you are addressing. The rule comes next. So you have to identify the applicable law about the issue raised. Then you need to apply this to the facts of the case and show analysis here as much as you can. Afterwards, you need to conclude what would be the most likely outcome. So you need like a mini conclusions after every single legal issue to show to the examiner that not only you are able to do the critical analysis, but you can also show what is the most likely outcome in this case, applying the relevant law. Your goal should be to identify at least 80% of all the legal issues and apply all the relevant cases and primary law to get a first class. Today we will revise gifts. It's a very important topic in equity and trusts, and I believe that you should be able to answer a problem question about it to be well prepared for your upcoming equity and trust examination. When three certainties are not met, trust fails. Alternatively, property can pass as a gift. So as you already know, for a trust to be created, there has to be three certainties: certainty of intention, certainty of subject matter, and certainty of objects. If a trust fails because either of these three certainties are not met, that's when we could have a look at a gift as an alternative interpretation of passing the property. Main rule is that claimant cannot rely on the law of trust to effectuate an incomplete gift. This was established in the case of Milroy versus Lord, and we call it a strict rule because strictly just a law of trust cannot be used to complete an incomplete gift. However, there has been some relaxation of this rule that we will go through. Refri is also an important case that you need to remember. Here, equity will not complete an imperfect gift, reiteration of the strict rule. What is the difference between a trust and a gift? A lot of students don't understand this. So a trust is a transfer of a legal title. As you know, there are two kinds of title. There is a legal title and there is an equitable title. So on the property register, whoever is registered the property on, that's a legal title, but equitable title is something else. Whoever may have an interest in the property is an equitable title owner. So a gift involves an intention to effect a transfer of absolute title in property from the owner to another person. In case of gift, absolute title transfers, whereas in case of trust, only the legal title transfers, whereas the benefit of the equitable title will stay with the original owner. Relaxation of the rule. The case of Rose is very important for you to remember for departure of the mainstream approach. So in the case of Rose, it was argued that if the donor has done everything necessary for her to make the gift, then equity will deem an equitable interest in the property to have passed to the person to whom she donated the property. So what does it mean? Basically, even if the donor has not followed absolutely every single formality to complete the gift, it can still be effective, even if the title has not been completed, as long as the donor has done everything in their power to do so. But the process can be long, and even if the donor passed away before the title is effectively changed, it can still be effective. The gift can still take place. Here's the problem question that a similar problem question may come on your equity exam. So it's important that you know how to answer this kind of problem questions. Peter invited his stepdaughter Emily to live with him in the house to take care of him when he was ill. He promised that he would give her his house as a gift in exchange for her taking care of him in time of need. Emily agreed, gave up on her career and moved in with Peter to take care of him full-time. However, Peter did not follow the formalities to effectuate the gift before he died. According to the intestacy rules, the property should have passed to the deceased person's brother. Would Emily be able to receive the property as a gift? That's the question. So you need to identify all the legal issues that arises on the problem question and assess it one by one by explaining what are the rules relevant to this problem question, the cases, all possible outcomes. So there can be different principles applying here, and your job would be to identify all possible interpretations of law based on this problem question. Issue 1 would be to discuss if Emily can establish that the property was a gift to her. That's what the question is asking. So the first thing would be to explain how are the gifts created, what are the rules for creating gifts, and are these rules satisfied? I would start with the case of Milroy versus Lord. This is the key case on creation of gifts, and you would need to explain that formalities have to be followed for gift to be effective, which is not the case here. By applying this strict rule, Emily cannot get the house as a gift because Peter has not followed the formalities. However, the strict rule of gifts was relaxed in the case of Rose, and you should mention how the rule was changed in the case of Rose, and if this can have any kind of impact on the outcome in this problem question. Well, yes, in the case of Rose, it was argued that even if the title is not effectively changed in the lifetime of the donor, the gift can still be effective. But the problem here is not that the title hasn't been changed. The problem here is that Peter has not done anything to start the process of transferring the title. So none of the formalities have been followed. Therefore, even if the court applies the case of Rose instead of Milroy versus Lord, which is the strict approach, it is unlikely that Emily would succeed on the given facts. Issue 2 would be to identify any other case that could elaborate on the arguments. The examiners really like when you can identify different cases and look at the same problem from different angles, providing really detailed critical analysis and deep thinking as to what kind of arguments you could do to apply different case scenarios to this problem question and elaborate on the critical analysis as much as possible. Details will give you a first class, as long as they are accurate, obviously. In the case of Maskell versus Maskell, although the transfer was not registered, the settlor did everything in his power to transfer the property to his son. So what happened was that they did the formalities. However, in his lifetime, the title was not changed. So it was not complete, but he did everything he needed to do. So in this case, the gift was successful. But this principle cannot really help in the case of Emily and Peter, because Peter has not done anything to transfer the gift. Therefore, even applying the case of Maskell, the outcome would not change. Issue 3 would be to have a look at any alternative route that Emily could rely on to get the property, despite not being able to establish a gift. And that alternative route would be proprietary estoppel. Proprietary estoppel is a remedial doctrine, and there are 3 requirements to establish successfully proprietary estoppel. And what these are the three requirements. First of all, there should be promise or representation by the defendant that the claimant will acquire some rights in the property. Secondly, there shall be reasonable reliance on this promise. And thirdly, detriment. So all these three requirements shall be assessed in turn and discuss whether or not Emily satisfies these three requirements. Promise and representation. This is easy because there was clear promise to Emily that if she moved in with Peter, she would get the house as a gift. So this requirement should be satisfied. Reasonable reliance needs a little bit more elaboration. First of all, you need to explain the law and apply the relevant cases. The relevant cases here would be Grizzly versus Cook. In this case, if clear assurances have been made and detriment has been suffered, it can be assumed that reliance has occurred. So this is the principle that was established in the case of Grizzly versus Cook that you can use in this case to make the point. The point is that this reasonable reliance requirement should be satisfied here because, in the case of Peter and Emily, because Emily was assured that if she moved in with Peter, she would get the house. Therefore, in relation to reasonableness, whether or not it was reasonable for Emily to rely on that promise, it can be argued that it was reasonable. Objective standard applies with burden of proof on the defendant. So it's not actually Emily who has to establish whether or not it was reasonable for her to rely. It should be the other party. The other party in this case would be the brother or nephew of Peter, who was the one who was going to inherit this house instead of Emily. So it would be on him to establish if it was reasonable for Emily to rely on Peter's promise to get the property as a gift. It is unlikely for unreasonableness argument to succeed in this case because it seems reasonable that Emily was clearly promised the property in exchange of her taking care of Peter when he was sick. And there are actually cases where this kind of proprietary estoppel has been established successfully, and it would be expected from you to cite the relevant cases to support this argument. Detriment is the last requirement that you would need to discuss. The detriment basically means that claimant is worse off as a result of having relied on the defendant's assurance. What does it mean, worse off? So basically Emily had a job and she had to give up her career and move in with Peter. That's her loss, that's her detriment. It's quite clear here. So there is an explicit link because of the representation, the promise that Peter made to Emily. She gave up on her career, she suffered detriment and moved in with Peter so she can take care of him full time. And as long as this detriment is neither minimal nor trivial, as it was established in the case of Lothian versus Dixon, no specific form is required. So the law does not give any specific requirements as to what detriment should be, but the claimant has to have lost something tangible, something that is not minimal. In this case, Emily gave up on her career, that it can be big enough commitment to satisfy the requirement of detriment for the purposes of proprietary estoppel. At the end, I suggest you have a conclusion to sum up your analysis. The conclusion would be that Emily most likely would not be able to establish that the property should pass to her as a gift because the rules of transfer of a gift is not satisfied, is not complied with. However, she can rely on proprietary estoppel doctrine to get the property, to acquire the interest in the property. My advice would be for a first class in equity and trust to follow these 3 steps. Have a look at our study materials for equity and trusts. We have the notes for every single key topic that you need to revise and study for your exams or assignments. So make sure that you read our study materials, receive personalized one-on-one tutoring every month. That's very important. So our one-to-one tutoring is like is a meeting with a tutor, one-to-one. This one is group class, and then we have one-to-one classes as well, where you will be given a personalized guidance. So a tutor will go through your assignments and exams with you to help you get a first class. So we will give you like personalized study plan just for you to maximize your chances of getting a first class. And thirdly, attend the free revision classes like this one. We have a few coming up. If you go to our tutoring page on the platform, you will be able to sign up for all the classes, and I suggest that you do so. You can join our over 20,000 law students in the UK who already get high grades using our platform. And you can see we have amazing reviews, and so many students already got high to one and first class in their exams. If you want to be the next one to be a successful first class law graduate, sign up at Simple Study now.